Hello, my dear friends. I am Dr. Waseem I Khan, Assistant Professor, Shri Shivaji Law College, Parbhani, Maharashtra, India. In today's lecture, we will discuss a third part of tort of nuisance, that is, defenses available for the tort of nuisance. So let's start the topic. Defenses for nuisance. So this introduction we have already discussed in the previous two lectures. As we know very well, the nuisance is derived from the French word neuter, and it is a Latin word nuisere, which means to do hurt or to annoy. If any person by his act, if other person is feeling discomfort and getting annoyed, then the person who is creating that particular nuisance and act will be liable for the tort of nuisance. So if by my act, if you are feeling discomfort, you will be entitled to file a suit against me for the tort of nuisance. If I am doing any work due to which if you are getting annoyed, then you will be entitled to file a suit against me for the tort of a nuisance, because nuisance is an unlawful interference with the use or enjoyment of land, and that's why the person who is feeling discomfort will be entitled to file a suit for the nuisance. So now we will move towards the defenses available for the tort of nuisance. As we have discussed that if the plaintiff wants to win his case, he must prove the essentials of nuisance. If he proves the essential, then only defendant will be held liable and plaintiff will get a compensation. But if the defendant wants to avoid his liability, he will be entitled to take the available defenses. By taking a defense, he can avoid his liability. So the first defense available for the tort of nuisance is defense of prescription. So if a person continues an activity on the land of another for a period of more than 20 years, so if the person is creating a nuisance, if the person is performing his activity for more than 20 years without any kind of interruptions, then after lapse of 20 years, the person will get a right to perform that activity for continuum. So if I am doing my act for more than 20 years and no person has taken an objection on my act, then after lapse of 20 years it becomes my right. Now no person will be entitled to file a suit against me, and if any person filed a suit against me, I will be entitled to take the defense of prescription. Why? Because I am doing that particular act since more than 20 years. So if any person is doing any act for more than 20 years, now he will not be liable for the tort of nuisance, and the person who filed a suit against that person, defendant will be entitled to take the defense of prescription. So prescription, long and continuous use, legalize an act. If a person is doing his act for a very long period, then that act becomes legal after lapse of 20 years. So the period of 20 years is to be counted from the day when the plaintiff comes to know the existence of nuisance. So now the question is that, that 20 years will be counted from the date of knowledge of nuisance, not from the date of act. So if the defendant is doing his act for more than 20 years, but if the nuisance comes to the knowledge of plaintiff before 6 months, now he will be entitled to file a suit, and defendant will not be entitled to take the defense of prescription. There is a case, Sturgis versus Bridgman. In that particular case, for more than 20 years, defendant had used a certain heavy machineries for his business. So in this case, the defendant was using a heavy machineries for his work for more than 20 years, and plaintiff physician constructed a consulting room adjacent to the defendant house. So in this particular case, the defendant was doing his activity by using heavy machineries for more than 20 years, and the plaintiff, who was residing adjoining to the land of the defendant, he constructed a consulting room exactly adjacent to the premises of the defendant, and he comes to know that due to the using of heavy machinery he was feeling discomfort. He filed a suit against the defendant, and the defendant took the defense of prescription, but the court held liable to the defendant by saying that the period of 20 years will be counted from the date of knowledge of nuisance, not from the date of activity of the defendant. So in this particular case, the nuisance comes to the knowledge of plaintiff prior to the filing of the suits, and that's why defendant was not able to take the defense of prescription in that particular case. So when defense of prescription will be available? Without any kind of interruption. If the person is performing his act more than 20 years, for more than 20 years, then he will be entitled to take the defense of prescription. So that is the first defense available for the tort of nuisance. Second one is statutory authority. So a suit for nuisance is not maintainable if the defendant's act is authorized by law or statute. If the defendant is doing that act which is authorized by any law or statute, then he will not be liable for the tort of nuisance. The suit will not be maintainable against the defendant for the tort of nuisance because he was doing that act which was authorized by the law, which was authorized by the statute. So if the statute has given me any power, power to do any act, and if I am doing that act, I will not be held liable for the tort of nuisance. And if any person filed a suit against me, I will be entitled to take the defense of statutory authority. So, construction of railway track and government work for the public interest. We know very well the railway causes discomfort to the person residing nearby the tracks due to the horn, due to the noise, due to the smoke, due to the vibration. The person are feeling discomfort who are residing nearby to the railway track, but they will not be entitled to file a suit against the railway department. And if any person filed a suit against the railway department will be entitled to take the defense of statutory authority because statute has given a power to the railway department for running the railway, and that's why statutory authority will be defense available for the railway department. They will not be held liable for the tort of nuisance. So work for public interest. Suppose if there is a construction of a road and due to which the many persons are feeling discomfort, but they will not be entitled to file a suit against that authority because they are doing the act by virtue of power given by the statute. And if any person filed a suit against that authority, the authority will be entitled to take the defense of statutory authority. So if the statute has empowered any person and if the person is doing an act by virtue of statutory authority, he will not be held liable for the tort of nuisance, but he will be entitled to take the defense of statutory authority. So these are the two defenses available for the tort of nuisance. I hope you understand this topic. If you understand this topic, please subscribe my channel, hit the notification button, hit the like button and share this video with your friends. Thank you. Thank you very much.